we have, because if I have it, you guys have it. We have lobbyists. We have a pit bill being drafted. And we're drafting. We're fighting. Damn, we fought real good last time, didn't we? They got Zippo. They got Zippo. Guys, they got Zippo at 3 o'clock in the morning of that last committee they went. When a doctor walked out of there convinced by us that what they were proposing was wrong. And we had him flip. And have you known that about 2 o'clock in the afternoon, the committee made the decision and they realized that they had lost? In the hallways of Tallahassee, there was almost a big fist fight. That's how adamant they were. They got really angry at this poor doctor. Haitian doctor. Good guy. But he realized what was happening. And he said, no, I won't allow this. Again, this year, we're going to have another fight. Here it comes. I'm telling you, it's coming. You saw that order. What he said, have you seen the articles with Rick Scott? May God bless this state. He wants PIP to be not mandatory anymore, to be, you choose. Of course, Rick Scott isn't the sharpest. That's in the box. But we have another war coming. Hopefully, winning this war, things change. Why? Because the year after that, redistricting. Everybody must be elected in November. Re-elected. Everybody comes for re-election because there's new districts and things can change. So they're a little scared of doing things. But we have some people on our side this year. This year we've been working from the day that we won forward. We've been working. We've got friends in the legislature. We've got friends everywhere now that are on our side. Anyway, they're coming at you. A legal issue that has just come in Orange County is something that is with Kairos, what is called the minimal record keeping, the rule, the administrative order. There is a case that State Farm convinced the judge that because the records were not at the minimum standard, they shouldn't have to pay for the PIP claim. Obviously, I think that that case is absolutely wrong in one way. The administrative code does not give what is called a right of private right of action. It is not permission for not to pay the claim. The department can come after that Cairo. The department can sanction the Cairo. The department can punish the Cairo. The department can spank the Cairo. That's their privilege. But it doesn't give the right for an insurance company to say, I've determined that you've broken that administrative code, therefore I don't pay. No. That judge was duped. And hopefully it's on appeal. I don't know, is there appeal filed on it or no? No? Wasn't our case, it just came out. That's the second part of this. Something that then, because everybody grabs onto everything. You have BI attorneys that say, well then I don't know you because you didn't keep the minimal record keeping, so the client. Don't know that. Okay? Don't know that. I don't understand how BI attorneys, I'm a BI attorney, I don't do that. You know, I get my clients paid and I try to get the medical provider at least something. Okay? Sometimes it's very small because the settlement is small, but I want to get them part of the deductible and part of their co-insurance. Assignment of benefits and disclosure and acknowledgement. The other day I was looking at assignment of benefits from ex-medical clinic. And it says ex-medical clinic. And Joe Schmidt hereby assigns the rights and benefits of the policy with Geico to Dr. No. And then I see the billing, ex-medical clinic. And it's ex-medical clinic that wants their money. But ex-medical clinic does not have a right to it. Dr. No has the right to it. How do you make that mistake? Dr. No has no right to that. I mean, Dr. No has the right to it. Ex-medical clinic does not. The assignment is owned by Dr. No. He owns the rights and benefits. Get it right. Get it filled out correctly. How about the one, Dr. No, Geico Insurance, the person who's insured with State Farm? So therefore, the policy rights of State Farm were never assigned. And I get this. How do you expect to get paid? They're looking at this stuff. Guys, they're going through your file with a fine-tooth comb. They're looking at your paperwork with a fine-tooth comb. Get it right. You get the assignment from the insured and from the patient, from the correct insurance company to the correct entity. And as a side note, you guys that have other clinics or other medical providers or other and are using the same software for the billing, please change the federal identification number. I look up your corporation and the federal ID number is completely different than the one that's in the head file. I'm saying to myself, where did this one come from? And then I think probably, because it's your program, you used it for billing other companies, and you never changed it. Guys, proofread. When you send it out, make sure that everything's right. Because they're saying, you're screwing IRS. That's what they're saying. And we're not going to be a part of it, so we're not going to pay. We're not going to be a part of doing harm to IRS, so we ain't going to pay. Come on, do it correctly. The disclosure and acknowledgement is one, where is it? Is one that's also a lot of fun. Disclosure and acknowledgement was made so that when the patient came on the first day, the doctor would tell him what was going to happen. We fought and said, what do we mean the doctor was going to do? The doctor was going to tell him the future of the treatment and everything? No. How does the doctor know? I mean, the doctor can probably figure out that for a week we're going to do this, but for the second week when I see you, I don't know what I got to do. And if you're going to make him a soothsayer and looking into his crystal ball, then he's always going to be wrong, or he's always going to be restricted to what he's saying. You never make any changes. That's okay. So we got them to change it, and it says on number 1, the undersigned insured person, or the guardian when it's a child, affirms that the service or treatment set forth below were actually rendered. This means that those services have already been provided. In those lines go what you did. If what you did the first day is simply a medical examination, that's all you put there. Sometimes it's only an x-ray. That's all you put there. If you provided treatment, well, put it. All right, put it. If you provided EMS, if you provided massage, put it with the medical exam and the x-ray. Put it. All it asks for is what was done on that day. Here. Then, what it says is that they were read, the patient was read these things. I have the right and duty to confirm that the services have already been provided. I was not solicited. the medical provider has explained these services to me, the ones that were done, and if I notify the insurer in writing of a billing error, I may be entitled to money. Okay? The insured person prints his name, signs it, and dates it. Next section is the person with a medical license. In other words, a licensed medical professional that has rendered or the medical director of the clinic. So, x-rays. All you did was x-rays here. The doctor wasn't in that day, but you took the x-rays, you did it, all right? You did the x-rays. The x-ray technician is the licensed medical provider. Yeah, he is. The PA, the physical therapist, the massage therapist, all of these are medical providers. That's what they said when they rendered it, the treatment. The doctor can sign it when he rendered that. Not you, not the receptionist. Person that rendered the treatment and that has a medical license. That's who signs it. That's it. Real simple. Or the medical director. Now, allegedly, this was all told to the insured, right? By that person. That person explained those four sentences on November 16th. And that's when the patient signed and put November 16th. If I see a DNA form that your medical professional rendering services signed on November 17th, then what does that mean? It could be argued that that person that signed didn't talk to that patient, did they? If they signed it the day after. Same day. Because supposedly we're sitting talking about this patient going up in the medical. Okay? Same day. Here's a little trick. I sent you a check for half of the medical bills and I put vote and final on it. And I listed out dates of service. And you guys go and deposit and say, okay, they owe me for the rest of the dates of service. Vote and final. Done. Finished. Kaput. You accepted this. This is called an accord of satisfaction. Which isn't really, because if I sent my credit card company a check for half of what I own, full and final, we'll see if I can get away with that, right? Let's see if I can get away with that. That'd be great. Or, you know, my mortgage company, I'll send them like, if I own $300,000, I'll send them $20,000 and say full and final, you know? Come on, it's not. But it's a very, very tough road to go after getting the rest. Be very careful. Be very careful with the check that says full and final, or doesn't say full and final, but a letter attached to the check says, if you accept this, it's full and final. Guys, don't deposit, don't do anything. Return it to them. Say, no, no, no. Send me your. If they catch you, they got you. This is a gotcha thing they do. It's called a drop check. In other words, they drop it in the mail and see if you fall for the mail. That's how they do it. It's a drop check. Kingsway used to do this a lot, U.S. security at the time. And now we're back to the beginning. And I'm going to allow Joe to elaborate on a lot of the stuff that I spoke. But again, if you don't help us in the case, you're not going to get paid. If I filed suit for you, it's because I think I can win. I am not. I'll tell you, and I guarantee you this. When I file suit, it has to be more than 75% sure that I'm going to win. Because I'm not going to waste my time. I'm not. Because the only thing I sell is time. That's my sale. That's how I get paid, the time that I spend litigating the case. So if I got a 50-50 case, I'm not gonna file suit. I'm not gonna take the risk. It's gotta be a 75%. But you know how many 75, 80s, and 90%ers I lose? Because when I set you for a deposition, you say, I'm not going. Done. Case is done. It's done. You know why it's done? Because there's no judge in the world that's going to allow me to win a case with the defendant not able to talk to the plaintiff. Doesn't happen. Doesn't happen. You guys have left, I don't know if you guys know anything about sports, but you know, you leave it out there, well, you're leaving it out there. Hundreds of thousands of dollars. I watch. I dismiss cases, and I see hundreds of thousands of dollars go by the wayside. Your money, not mine, yours. I see mine too, but yours. Money that you've already done the services, that you've already performed everything, and you've decided that because there's a deposition, you don't want to get it. Hundreds of thousands of dollars. As a matter of fact, I think every one of you probably started with me on a revision. Remember? When we first started, that my people went in there to your thing and got you thousands of dollars very quickly. You guys have abandoned that money. Well, you're abandoning this one too. This takes a little more work, but you're abandoning it too. Same way. Only the work is a little more. It isn't just going into your storages and printing out your files and working. Now it's working. A little more. It's the same thing. I betcha that I probably got you 50% in that revision quickly. So we have another 50%. So if I got you $100,000, you got about another $100,000. But if you want it or not, I'm willing to go all the way. Trial, appeal, the home run runs. Come with me. It'll be fun. I promise you. Another thing. The moment they find out that you're fighting back, they don't want to deal with you. Because you're one of them that is a pest. You're one of them that's going to fight back. So you know what? I'd rather pay you but not pay the 30 that don't fight. Be one of the ones. Thank you. Joe.
I don't think I need a microphone. My voice is loud enough. Let me introduce myself. My name is Joe Gleason, and I am the attorney in the Orlando office for Gonzalez and Associates. And I've been with Mr. Gonzalez for the last 3 years since he opened the office. And some of you are familiar faces and some I haven't met yet. And if I go, first of all, I want to thank everybody also for coming out. Just your effort in coming down to this seminar, which is presented for our clients' benefits, shows me that you care. And these are the clients that we enjoy working with. One of the things that Neil said about Mr. Atwater here, it bears repeating. During these challenging economic times, Florida families cannot afford to spend one more dime on increased insurance costs. It's my mission to stamp out insurance fraud and to ensure these cheats who are making money off the backs of Florida drivers serve real time. I listen to that statement and then I look out to this crowd and I say, who here does that apply to? Any of you hard-working small business people that are providing valuable health care services to injured people on the roadways of Florida should be slapped with a charge like that. Mr. Gonzalez told you a personal story about his feelings towards insurance companies. I'll add to that by saying, in my 25 years experience of being a lawyer, I've most often enjoyed representing people like yourselves, who I consider to be the underdogs in a very difficult fight against insurance companies. And when Mr. Gonzalez says we're ready to go to the wall for you all, he's also saying that I'm ready to do that as well, because I'm primarily responsible for the Orlando office.
So thank you, Joe. You see this on your tickets. This is the SMI mousetrap. It's the one you say, who are you? I'm from SMI, I'm this place. All right, call them. Call them. I got nothing to say to you, call them. That's what this is about. This isn't about not trying to, you know, be a big guy and say that I got to. It's about putting that up there and say, you have questions? Call them. You want to see the file here? You have questions? Call them. When they get here and they're on the phone, if they tell me I can answer a question, I'll answer it. If not, no. That's what this is about. And you're welcome to take them. Those of you that don't have them, we've got more, right? We got more, all right? So you're welcome. The next thing, I'm sorry, is this survey that's out there too. It's a survey about this seminar, this process. That's something that I would really, really want you to do. I mean, I want to know that I'm helping you guys. I want to know that I'm coming across, that you guys want this, that you guys want to be kept up to date, that you guys want this. So what I want is a survey that you answer truthfully, please. If we're doing a lousy job, let me know so I can get better. And last but not least, I have opened up a new division in the firm, which you see in the back there. That guy that I don't know is doing bankruptcy. So that's something that's now very prevalent, and I believe that very many bankruptcy attorneys are doing it wrong. What are they doing wrong about that is that they quickly want to file bankruptcy for a person, hurting their chances to do other resolutions of their problem. What I'm trying to offer is a very complete, comprehensive look at your economic situation and that person and say, maybe bankruptcy is the right thing, but not at this time. We need to wait another one. We need some assets that we need to fix. We need to protect some other assets. In other words, a real look, a real consultation, a real, you know what? It's like a cancer doctor who's going to give you chemo, but if there's a reason why that chemo will hurt you, he can't give it to you. That's because he knows you complete. He knows your whole body. Not just, let's give it to him, right? There are consequences to everything we do. We've got to make sure that every consequence we've taken care of and make sure that it's clear. It's the same with film. It's the same with the eye. It's the same with everything. Every time I make a legal move, there is a consequence. Intended, sometimes unintended. Got to make sure that that's it. I thank you very much for coming. I thank you very much for being my client.